My name is Attorney Cynthia Petruka, and I'm here to discuss a very important topic for employees. Should you hire an employment attorney? That is a very loaded question that I get asked quite often when clients are trying to get services from my firm. And the first thing you need to really ask yourself is this: have I communicated my problem to the employer? This is a very simple question, but a lot of employees have not even spoke up to their employer to articulate what's actually going on in the workplace. A lot of times I talk to clients who are assuming that their employer knows what's going on. Sometimes that assumption is based in good faith beliefs that something so obvious that somebody should be seeing what's happening and paying attention. And other times it really is in the employee's head. So this is not a could have or should have or ought to know, but you must absolutely make sure that the employer knows what problems you're experiencing so that they have the opportunity to fix them. And how should you communicate? I always advise my clients to communicate in writing. Why? Because if you communicate in writing, it's a lot more difficult to deny that you had knowledge of something. Of course, you need to track who you sent this communications to and on what date and how you send it to them. But in today's day and age, a lot of employees are able to communicate either by text message or by email. So it's very simple to reach out. Who should you be reaching out to? Well, you want to get somebody at the company involved. Usually, if you have a human resources department, that's where you start. Other times, I see people reach out to their ethics departments, but you have to start somewhere. If you're courageous enough to complain, and I'm not talking about a 20-page rant, but I'm talking about a clear and concise statement to the company, 1 or 2 pages maybe at most, that communicates what your concerns are, and the company still fails to do anything. What do I mean by failing? Not just they didn't give you what you wanted, but they failed to investigate, they failed to listen to you. If they fail to do the correct action, then that's when is a good time to engage an employment attorney. If you're serious about your employment dispute, you really want an employment attorney to have that authority for you and be that voice for you in communicating with your employer. That's how you get taken seriously. But you also don't want to disregard your mental health. During an employment dispute, you're probably going to be at one of the most stressed out times in your life. This is your livelihood at stake. So you want to be prepared to go through mental health challenges. And to prepare for those, you should have resources in mind to help you. The first resource that you should have in mind is your EAP, or your Employee Assistance Program. Now, these are programs that your employer pays for and provides to you free of charge or at a very low cost. A lot of my clients tell me that sometimes they can get on demand therapy sessions, meaning in the middle of the day, they can just willy nilly call their EAP program and get on demand therapy sessions. That is a valuable tool to use. If you don't trust EAP, or you don't feel like using them, or you might not even have the option to use them, the other traditional model you might want to consider is actual bona fide therapy. You might want to get a dedicated therapist that you can connect with virtually or in person that you see on a regular basis to talk out some of these issues. If you're not into therapy, you might want to consider connecting with your spiritual side. And that doesn't necessarily mean a religious entity, but what gets you going? What are your values? What do you believe in? Reconnecting with your values can really help you focus on what you want to see happen next and help you make the important decisions you need to make during an employment dispute. If you connect with an employment attorney, you should absolutely understand that there's likely to be a cost. Most employment attorneys do charge something. There's three main models that we see in employment law. The first is the flat fee model. That's a lump sum amount that's predetermined for a scope of work. The second is a contingency fee. This is a percentage that your attorney will take from your settlement if there is a resolution. The benefit of a contingency fee is that if you don't get anything in your settlement, then you're putting the risk completely on the attorney. The last thing you might want to consider with the billing model is an hourly rate. A lot of attorneys do still charge by the hour. This is a very traditional way that attorneys charge. They usually require a retainer up front, which is a representative amount of what they think the work might entail. It's a lump sum amount, and then they will send you a bill on usually a monthly basis that draws down on that retainer. Sometimes you'll see attorneys mix all three of these type of billing models together, or sometimes two. For example, my firm charges a lot of flat fees and contingency fees, where we're giving people a pre-scoped objective and a flat fee for that, and also saying that if we get you a resolution, we'll also take something at the end. After you hire an attorney, your work is not done. You still have a lot of work to do in your case. You are the most important witness in your case. So your attorney is going to rely on you for facts, for dates, for people involved, for locations of events. You want to be sure that you know your facts before you talk to your employment attorney. And you also want to be prepared to give the names of witnesses. There's no such thing as an anonymous investigation in an employment dispute. You have to be courageous enough to give the names of real people that are involved in the case that can help tell the truth about what happened.